Okay, welcome everyone. My name is Jonathan Whitmer-Rich. I'm Associate Dean for Academic Enrichment here at the Cleveland Marshall College of Law, Cleveland State University. I'm delighted to welcome you. We have over 40 participants already, and I think more joining to this, our next installment in our Faculty Spotlight series. We're delighted to have Professor Krista Laser, who will be giving us our 1-hour CLE on intellectual property law issues in non-fungible tokens, NFTs. So I'm really looking forward to this talk. Professor Laser, to briefly introduce her, this is her second year at the law school. We're really delighted to have her on our faculty now. She spent nearly a decade practicing IP law at major firms on the East Coast, WilmerHale and Kirkland & Ellis. She has very deep experience in patents, trademarks, copyrights, and other areas. Her research focuses on intellectual property and innovation, and her scholarship has been cited by numerous scholars, by the United States Court of Appeals for the Federal Circuit, and in briefs to the United States Supreme Court. So with no further ado, I'm going to turn it over to Professor Laser. First, I guess a couple quick announcements. Number one, if you are wanting CLE credit for this event, at the end of her talk, before we start the question and answer part, we will be launching an online poll. You need to answer a question in that poll. By answering the question, whether you get it right or not wrong, but by answering the question, we will be able to record your attendance and thereby be able to confirm that you attended the event and you can get the CLE credit. And as I just mentioned, we will have some time for Q&A at the end. If you have questions as we're going along or at the end, you could submit them in the Q&A function. And then I'll be taking a look at those and asking Professor Laser some of those questions, whatever we have time for at the end. Okay, so with that housekeeping out of the way, I now turn it over to Professor Krista Laser. Krista, thank you.
Hi, welcome, and thank you, Jonathan, for the kind introduction, and welcome all of our participants. I'm so happy to see that we have so many people joining today. So today I'm going to talk a little bit about the intellectual property issues of non-fungible tokens. So for those who are not familiar, non-fungible tokens are tokens that are used to signal usually digital artwork, but it could be any type of digital asset on the blockchain. So the word non-fungible token comes from these two distinct parts. Non-fungible means that it's not easily replaceable with something else of the same type. So an example of something fungible might be money or cryptocurrency. I can give you $1 and it's the same thing as you giving me $1, or I can give you one Ether or one Bitcoin and it's the same as you giving one back to me. But artwork is not fungible. I can't give you a Monet and have it be the same as giving you one of my photographs of a lovely sunset or something like that. Those pieces of art are non-fungible. And then the other part of a non-fungible token is token. This means it's an item that gets associated with a smart contract for sale of a digital asset. So a non-fungible token is simply an entry associated with a certain digital asset. It's not interchangeable with other assets, and it's typically coded on the blockchain using a smart contract. NFTs can be minted on any blockchain that supports the use of smart contracts. Most commonly, this is done on the Ethereum blockchain. So one example of smart contracts are kind of things that it's very different from what you might imagine as a lawyer. If we have people that are first-year law students or lawyers listening to this, a smart contract on the blockchain is not the same as a contract that you or I might think of when we think of the word contract. In association with NFTs, a smart contract is essentially a program. It makes it so that there's an automatic transfer of ownership of a digital asset at the time that a person pays for ownership of that assets. The common Ethereum smart contracts for NFTs are ERC 721 and ERC 1155. But essentially, these contracts are not actually providing intellectual property rights. These are not contracts that tell anyone what the scope of the rights are around purchase of that asset. It's very much like if I handed you money to buy a painting, say a lovely Monet painting, it's an original, I hand you money and you give me the painting. we have exchanged that item, and in the real world, it's very easy to do that because you can just hand money and receive the physical item. But when you're looking at digital assets, there has to be some way to verify ownership of that asset. And these smart contracts are essentially programs that are used to verify ownership of those sorts of digital assets. Now, some platforms where you can purchase NFTs will have sort of general terms and conditions that apply to these sales of digital assets. But most platforms don't have anything that tells you what you're getting from an intellectual property perspective for the items that you're purchasing. So just to backtrack a little, for those who have more technical knowledge and less legal knowledge, it's also important to understand how copyright works, to understand some of the intellectual property issues in these non-fungible tokens. So when we're talking about something like a physical world painting, when you purchase that painting, you don't get all the intellectual property rights in that painting. When I purchase that Monet painting, I don't get the right to scan it, take photographs of it, and reproduce it. Or let's take something more modern, where that might have copyright protections that are in place. You don't have that right to scan and reproduce the work without authorization of the copyright holder. So today, just as a disclaimer, I'll be providing information mostly about United States copyright law, but because most countries in the world have signed international treaties that try to normalize copyright law, typically these laws are very similar from country to country throughout most of the developed world. But essentially in the United States, copyright is going to exist at the moment of creation of a work. So as soon as it goes from idea to implementation, this is something where you've put your ideas into creating a photograph or a painting, or perhaps a digital piece of art. It could also happen if you've written a song or if you've taken a video and now you have your video fixed in a tangible medium. That's when the copyright exists. Copyright exists as soon as the work is fixed in a tangible medium, whether it's a photograph, a digital file, a video, anything like that. Publication of the work isn't required to get copyright protection, and registration of the work with the Copyright Office is also not required to get protection. It's inherent. This is a right that exists as soon as it's created, regardless of what you've done with the work. Now, copyright is not a right to use what it is that you've created. So you might have some circumstances where you actually don't have the right to use or reproduce your own work because there are some other rights that block your ability to do so. All of the use of images and expressive works has this web of interweaving rights. And if you don't have all of those rights, you won't be able to reproduce that work with, at least without legal authority. So essentially a copyright, if it's not a right to use, what is it? It's a right to exclude. It's a right to prevent other people from doing certain things with your work without your permission. And specifically, copyright gives you 5 particular rights, one of which is the right to reproduce the copyrighted work, meaning I'm making a copy of it. Another one is to prepare derivatives of the work. So this is something like if one person makes a statue and another person takes a photograph that has that statue in it, that could be considered a derivative work because it's incorporating that work. Another example of a derivative work could be if you have a piece of music and you use that music in a video. That is a derivative work of that music. Another thing that you have the right to do with copyright law is to distribute copies of the work to the public. So one of the rights as part of the bundle of rights in copyright is the right to distribute. Another one is the right to perform the copyrighted work or to display the copyrighted work. So this is, for example, being able to hang the painting on my wall. That would be one example of a display right. So if you create a copyrighted work, let's say you make a photograph or a piece of digital art, you have a copyright in that work that exists as soon as creation. And then you have the right to exclude others from reproducing, modifying, distributing, performing, or displaying that work that you've created. Now, if you create a work that has some components that come from other people, that could prevent you from distributing your own work. So for example, if you make a TikTok video that has a song by another artist that you didn't write that song, that's some famous musician wrote that song, and it's part of your video. You upload that video to TikTok, and you could have a copyright in your video. You created it and fixed it in a tangible medium, but you might not have the right to actually distribute that video on other platforms, such as by selling that video as an NFT, because you don't actually have all of the rights to all of the subcomponents of that work. So anytime that you're sharing a work or selling it as an NFT, you're going to have to make sure that you have all of those underlying rights that come into play when you're creating a work. So there are certain platforms that will have licenses available for its users, like TikTok, for example, will have some licenses in place from music artists. But oftentimes, if you're trying to distribute those works on other platforms, you won't be able to take advantage of those licenses. Another example of some situation where you will have to get rights from other people in order to use the work is if you have a right of publicity issue. So a right of publicity is something separate from copyright law. Wherever you're taking an image or likeness or name of a person and you're using that in your work, you have to worry about whether that is taking some kind of commercial benefit that that person would have otherwise been able to receive from their likeness, or taking some kind of privacy right away from that person. So if you have pictures of people or use of their name or likeness in your NFT, you might also have intellectual property issues with distributing your work as an NFT or a piece of digital art. You have to make sure that you're going to have all of those different rights. The rights to your own work, the rights to all the works that are incorporated into your work, like music from other people, or perhaps pieces of art from other people that you've incorporated into your work, statues that are part of a photograph that you took. You also have to worry about whether there are things like right of publicity violations. Is there a person that appears in the work and you haven't received authorization from that person to be depicted in the work? There are a lot of other tort law issues that could come into play if you have depictions of people as well. So for example, the false light, you have to worry about whether you're portraying somebody in a false light, because that can be actionable under tort liability as well. But coming back to intellectual property issues, the important thing to keep in mind when you're creating a work is that you need to have ownership over every piece of creative work that is incorporated into what it is that you're selling. Now, people might think that when you buy a physical print of art, that you are receiving some other type of right beyond just the right to hang it up on your wall. That's not usually the case. Most of the time when we buy items in the physical world, all that we're receiving when we purchase that painting or that print is the ability to have and hold that exact painting or print. And you can usually hang it up in your house or some other personal place. But you don't actually receive the rights to those 5 key pieces of the bundle of rights that come with copyright law: the right to reproduce, the right to modify, the right to distribute, the right to perform, the right to display. So for example, displaying it at a paid exhibit or something like that. Now, if you have an NFT, the same applies. When you buy an NFT, if that marketplace doesn't have a license that gives you those rights, you don't actually have those rights as a purchaser or owner of an NFT. All you have is ownership of that particular copy. And an NFT is a digital asset. It's just like a painting. it's an asset that you have a copy of. You have one copy usually, and you do not actually have the right to make copyright use of that item. So you can't take the painting that you just purchased and scan it and upload it and sell it as an NFT. I know a lot of people might think that if you are the owner of some famous collectible, perhaps, and you would like to have an NFT issued for that, for a digital image of that item, you often will not have the underlying copyright rights to do so. Now, NFTs can be used to signify ownership of physical assets as well. They're not always used for ownership of digital assets. And in that case, you can specify that the ownership of the NFT is transferring physical ownership rights over the item as well. So you can do this, for example, you can have NFTs for sale of a property, for sale of a physical painting, but all of that would have to be specified in the NFT that you're creating. So let me give you some examples of what an NFT might look like. I'm going to share my screen, and I'm going to show you two NFTs, which are of photographs that I took because I didn't want to end up in any kind of copyright problem here. Oh, if the host, would you guys mind enabling screen sharing for me? While that's getting set up, if you go to OpenSea, OpenSea.io, that's OPENSEA.io, and you can follow along with this if you want to. You can find my name on there. I'm Krista Laser on OpenSea. Right, it looks like screen sharing is now enabled. All right. So are you guys able to see the screen now with the purple sunset on it? I think so.
Yes, I can see it.
So perfect. All right, so this is an example of what an NFT might look like on the OpenSea platform. Now, OpenSea is just one of many marketplaces where you can mint and auction off NFTs. So here I have the image that is part of the NFT. This is a photograph that I took, and so I have the copyright rights to that photograph. Because remember, anytime that you create a work that's fixed in a tangible medium, like making a photograph of something, you get that copyright in that item. So, so I have rights as part of my ownership of the copyright in this photograph and creation of this photograph to do things like reproduce, modify, distribute, or display this work. And I'm selling this NFT. And if you note in the description here, I've included a description of the item, a colorful sunset on the shores of Antigua with silhouettes of palm trees and clouds. And I've stated what the owner will receive. So it says the owner will receive a high quality digital download, a one-of-one limited edition NFT of this digital artwork, and unlock hidden poetry content. So if you notice, this does not include any copyright rights. There isn't actually a right as part of this to do those things that we would get from copyright, like reproduction or display or modification of the work. Now, I have tried to add other things in here, like access to unique downloads or unique content. Now, the smart contract is what enables people to have access to unique information upon purchase of the item, and also the setup and the software associated with the platform gives access to that unique information and can enable it to be unlocked upon purchase. But this particular item does not include any copyright license. Now, to show you a counterexample of what it might look like if you have an NFT that has no copyright. So let me just make this a little bit smaller. Hope it still looks okay. So this is an example of somebody else's NFT. This is part of a collection of NFTs, unidentified mystery animals. And these are actually NFTs that are sold copyright free. So this particular NFT provider has stated in the description that all the contents in this specific collection are copyright free. And we encourage you to benefit from their existence to the best of your ability, royalty free. They're saying that you do not have to pay royalties or licenses to reproduce this work, distribute, display this work. So essentially what you're getting as an NFT holder here is simply ownership. So here it says the only true ownership here is of our original NFT artworks. So you are getting, just like you would buy a painting. You could buy a painting in something that has no copyright protection associated with it anymore, like a painting from the 18th century, for example. And, from, maybe earlier, you can buy a very, very old painting that doesn't have any copyright protection associated with it. And that painting would be copyright free, but you would still be the owner when you purchase it. So you own that physical item, even though all of the public has the right to reproduce, distribute, display, modify that work. This is the same thing for NFTs that are provided without any kind of copyright, or with this sort of waiver of copyright. The other way you can think about this is as a license. You can think about this as a modified license that grants everyone in the public the right to have all of those copyright rights in the work. It's very much like if you had something in the public domain because it was old enough. And then, so with this one, if you purchase this NFT, you're not really getting anything beyond what any other member of the public would have, except that ownership, just like ownership of a painting. Now, I'll give you another example. This is another one of NFTs that I've made of my photographs. This was another photograph that I took in Antigua. This one is different from the first example because it includes a modified copyright license as part of the sale of the NFT. Now, this is very unusual. Most of the time when you're looking at items that are sold as NFTs on OpenSea or other places, you're not going to have any kind of copyright license as part of that purchase. So this one has a description. It also has a link to unlockable content about downloading a high quality item. It's a one-of-one NFT of the digital artwork. But this also includes a very quickly written, but still okay copyright license that essentially says that I'm the copyright holder, hereby grant to the owner of the NFT for the duration of the ownership of the NFT a worldwide non-exclusive royalty-free non-transferable license for personal non-commercial use. So this is essentially saying that if you want to do something like make a photographic print of this item, you could do that without getting additional authorization from the copyright holder, which is me. Most of the items that are sold as NFTs, you wouldn't actually have the right to make these large sort of printouts. You couldn't go bring the item to a photograph printer or somebody that might make a canvas or a metal print of one of these works and ask them to print it without getting that kind of licensing language. Those print shops are going to ask you, okay, show me the license that shows that you have the right to actually reproduce this item by making a physical printout of it. So this particular NFT is going to include a right to reproduce and distribute for personal use. And this actually would transfer from owner to owner, because anytime you get an owner of the NFT, let's say one person purchases this work, it's a one-of-one digital edition, so only one person is going to have access to that license. When that person, or if that person sells the NFT to another owner, that new person would become the owner of the NFT and have the copyright rights transfer with that as well, because anything that comes with ownership of the NFT is going to, under that smart contract, be transferred upon ownership of the NFT. So let's say if you have some situation where you have an NFT in some sort of digital asset that has value in a digital world. So I'll give you an example of a video game. Let's say you have video game assets like a new skin for your character in your video game, or something like a new weapon or a new vehicle for an item in a video game. Now, the owner of that video game could set up NFTs that would enable tracking of those in-game items. But typically, they're just purchased within the game, and they're owned only in the sense that you receive an item associated with your character when you're logged into your digital world. It can be very difficult to sell those items unless you do some kind of workaround, like selling your character and then quietly giving your username and password to the person who purchases your character in order for them to access it. That's how people have often done this when you're looking at in-game items. There's this example here, Gods Unchained. Now, this is an example of a card game that uses digital assets and allows ownership of the cards using NFTs. So each of the cards that are sold in this game are associated with NFTs. And because the NFTs enable easy transfer of digital assets, these NFTs will actually give you the right to those in-game items within the game. So these are a bunch of different examples of what an NFT might look like in these different contexts. So
I'm going to jump in, Krista, and ask a quick question that someone asked about
Please.
some of the examples you were just giving. So first of all, the copyright-free creature that you displayed, one question is, why is that referred to as copyright-free instead of as a license? Is there still technically copyright protecting that, or does it really not have any copyright because it's being stated as copyright-free?
Yeah, that's an excellent question. I'm glad you interjected with that. So the interesting thing about the copyright-free language is that it isn't really consistent with what you would normally expect for granting a license for something to be entirely copyright-free. So you guys might have heard about something like Creative Commons. Creative Commons is a contract that is used for people to provide access, copyright or copyright licensing to a large number of individuals online under certain conditions. And one of the things that you can use the Creative Commons license for is to grant a complete copyright-free license to the public. You can do a sort of public domain dedication as part of your Creative Commons licenses. You can also do something like a non-commercial attribution required license under Creative Commons. Now, that's not what they did. So one thing they could do is say, these works fall under the Creative Commons license, XYZ, and pick one of those Creative Commons licenses in order to grant that public right with more precise language that is more easily enforced under the existing legal frameworks that we're familiar with. They didn't do that here. They just have this sort of broad statement about copyright free. That's probably enough under the law to give a license to that work to the public, or at the very minimum to the copyright holder. But it's a very interesting question, because you could end up with a situation where, let's say if they try to revoke that license. So normally copyright licenses are revocable. So if the person tries to revoke that sort of copyright free license, can they do that? That would be an interesting legal question to figure out. I think likely the court is going to say that this language suggests something like a perpetual royalty free license to the work. But that's a great question.
That's great. And one additional question, because it's about what you were just displaying. When you show your these photographs, offer for purchase the NFT, it's a 1/1 limited edition. What does that 1/1 limited edition mean? Is that a promise not to sell it to others? Does it mean you lose rights over that? What does that mean?
Yeah, so a one of one is very much like if you had a painting or a photograph and you did a one of one print. So if you have a physical print of a photograph and you agree as part of your printing for that, you sell it to someone and say, this is going to be a limited edition one of one print of this item. That gives that owner this sort of assurance that you are making a promise to them not to make additional reproductions of that item in that medium. So if you have a digital asset and you say, so in the example of my photographs, and let me just reshare my screen again so you guys have that in front of you. So in the case of, say in the case of this purple sunset one, it's a one of one limited edition NFT. That's going to be viewed as sort of an informal agreement not to produce additional NFTs of that item. So essentially saying that nobody else is going to be able to own this NFT unless they purchase it from this auction or from the person who owns it after this auction. So essentially, just like a one of one limited edition physical print, you're only going to be getting one NFT of this item that gets produced in history. So it creates a sort of scarcity. Now, not all NFTs are one of one. There are other examples where photographers, for example, will put a 15 of fifth, or one of 15. Maybe your NFT is one of 15 copies of this item. So you have 15 separate digital tokens or NFTs associated with that particular photograph, but the author or the copyright holder or photographer is agreeing to limit the total number of NFTs to that amount. There are other situations where platforms will allow unlimited editions. So this is something where if you don't have a limitation, then you say, well, what am I actually owning when it comes to a digital asset? It's like if you were to buy a print from a print shop and there's no limited edition print. So let's say you order a copy of a poster from Amazon or something like that of your favorite band. They have some poster that they put out, and you order a copy of that from Amazon. You get your poster. Now you have a print of that poster, but it's not limited edition. So you have no guarantee that they're not going to print out 1,000 or 1,000,000 other posters of that. So some NFTs do not have limited edition. Some are, you're just getting this one digital token, and you can have the situation where the photographer prints out another digital token or mints another digital token of that same item. So unless you have a limitation in the language, like one of one limited edition NFT or one of 15 limited edition NFT, you don't have any protection as the purchaser that the photographer isn't going to create additional items. Now, there are other platforms other than OpenSea that guarantee the rarity of these items. I think Super Rare or some other ones might have certain guarantees and protections that the items that are being sold in the marketplace are actually limited edition and do have the scarcity that are represented. That's a great question. I think actually that it might make sense to jump a little bit into some of these questions, because I'm seeing some really great questions pop up.
Excellent. So there's one that just came up, which I think is a good follow-up to what you were just talking about. So if I purchase your one of one painting here for $1 million, your photograph, I'm sorry, and then you actually are so excited by that sale that you just decide, I'm going to sell another NFT of the same photo. So now it's, do I actually have a legal remedy there, or is that just kind of some kind of promise to you? Is there, what would the action be on my part?
Yeah, so this is really interesting, because typically this is something where you would have a breach of contract action, but this isn't a very firm contract. It's very difficult to say exactly, what's the scope in terms of this contract. This is very limited language. What does that mean? A court's going to have to use that very limited language to interpret what it is that was actually breached in this contract. So And you don't know, okay, who's breaching the contract? Is it the platform that's breaching the contract? If you put another one up there and they don't check for the rarity of that item, and the platform has some protections of rarity, maybe you sue the platform for that. But you can also sue the artist. You can sue the artist if their language that they include in that description is something that indicates a promise that's accepted by that purchase button. So oftentimes, when you're trying to figure out whether something is a valid contract or not, you need to look at whether there's an offer and an acceptance, and then you figure out what that language is that was actually accepted between the parties and forms part of their agreement. So I think, yes, you would have to look at a breach of contract suit. There's a note in the question, would there be any copyright claim here? No, because the owner does not receive a copyright right to the work. So when you purchase an NFT, you're getting, just like you would purchase a painting, you're getting some representation of that particular asset, just as you would for a physical asset, but you don't actually receive the copyright right in that work. So if I, as the copyright holder, make additional reproductions, that's within my copyright right, because I haven't sold that copyright right to you. And actually, this is another example. If you look at this Pink Sunrise one, where there is a copyright license that's granted, note the difference between a license and an assignment or purchase of those copyright rights. So a license is going to mean that I, as the copyright holder, am giving some of those rights to you as the purchaser or licensee, but I can still retain some of those rights. So here there's a non-exclusive right. So the difference between exclusive and non-exclusive is going to be that when I give someone a non-exclusive right in this work, I'm giving them the right to do those things. I'm saying, I'm not going to exclude you from doing these things of reproducing, modifying, displaying the work. But I'm not going to promise you that I'm not going to do those things or give other people the right to do those things. So when I have a non-exclusive right that I'm granting to the owner, that's going to allow the owner to have that freedom from lawsuits from me for copyright infringement under the terms of the contract. But there's no right for the licensee or the purchaser of that NFT to sue me for copyright infringement for doing something like reproducing that work. So if I make a print of this photo or sell a print of this photo, because this is non-exclusive, that's not going to give the right to that licensee to sue. Now, if you had an exclusive right, then you could have a situation where the licensee could have standing to sue for that. The other one that you could have is if this is an assignment. So if I were to say in here that I hereby grant an assignment of the copyright, that would be a really, really interesting NFT. Probably should have done that. That would have been really interesting. So I'll have to do that for next time. But if I had done an assignment of the copyright, that would give the owner of the NFT the ability to do all of those things that we associate with copyright rights, to be able to exclude others. So if this had been an assignment and I had said, I hereby grant an assignment or transfer all of my intellectual property rights associated with this photograph, then the owner of the NFT would have the right to sue other people for reproduction of the work, including the original photographer. So if that were the case, if it had actually come with an assignment of copyright rights, then the NFT owner could sue the photographer for doing things like reproducing the work without authorization of the new copyright holder. But without that, you don't have those rights as the purchaser of an NFT. Most people don't realize that. They don't realize that when you have an NFT, you don't get any copyright rights. Most NFTs you're getting are like this purple sunset one, where the best you can get is maybe some kind of breach of contract suit if you don't get the benefit of something like this promise that it's going to be a limited edition. So most of the time when you get an NFT, all you're getting is something akin to getting a limited edition print of the item that you're purchasing, or in some instances, not even a limited edition print. It's like buying a poster from Amazon.
And so
All right,
just to clarify, if I'm buying a digital NFT, that probably includes a right to like display it in my own home, but to display the digital image in my own home, not necessarily to say print it out, because the printing out would be creating a copy in another medium, right? So I just have the right of that. I own the digital image.
So actually the NFT doesn't even give you rights in the digital image. So without having some kind of language in the marketplace, so many marketplaces will have general language that says that when you purchase an NFT or when you post an NFT to this platform, you're going to grant rights to do things like to share the work digitally or something like that. But most of the time, the default that you're getting doesn't even include rights to the copyright rights over the digital image. So you buy the NFT, it's like buying a print. It's like saying, I own this, but I can't really do much of anything with it. So, even if you put up a one of those digital artwork frames and you have your NFT displayed in your home, you might have an argument before a judge. Let's say you purchase it from a platform that doesn't have any language like that written in to the general terms and conditions of using the platform. You might have an argument before a judge that there's something called an implied license. So copyright licenses can be express or implied. If they're express, it's something like this example of the pink sunrise, where you have some language that says, here are the exact terms and conditions of this license. But you can also have a situation where there's something called an implied copyright license, where the circumstances imply some copyright rights. So you may have a situation where a judge would say, well, by purchasing the NFT, there was an implied license to do certain limited things with it, like, for example, take the image and store it on your hard drive. Typically, that's considered making a copy of an image, but you might have that right implied, or it could be a right that's included within the language of the description. So, for example, if you have a description that says you'll get a digital download, that might imply a right to download the image and make a copy of it on your computer. But typically, when you purchase an NFT, you're not getting copyright rights, even to things like displaying it, displaying it in a different medium, like printing it out and putting it in your home, or sharing it to social media. Now, there are some exceptions to that, depending on what platform you're looking at. So I think so for example, NBA Talkshot, which is a
there's a question here about NBA in particular, and saying, are there any display rights that NFT purchasers are granted, say through the NBA, if you're aware of that?
Yeah, so NBA Talkshots grants is one of those platforms that has a general license that applies to all of the purchasers, and it includes a limited license of purchasers to display the NFTs and the virtual trading card on third-party marketplaces or websites, with certain caveats carved out. There were some proposals, for example, from the creator behind CryptoKitties, which is another popular NFT, to create something called the NFT License 2.0. And this was a proposal that would have allowed those who purchase NFTs within those platforms or that use those licenses to have even commercial distribution rights associated with ownership of that NFT. So essentially, you just have to look at the particular contract language associated with that platform, and layered on top of that, whatever is in the description of that particular NFT. Because you could have a platform that doesn't have all of those rights provided as part of the general contract, or you could have a platform that has some rights provided as part of the general contract, but you might want to add to those. And so when you're selling those NFTs, if you're the owner of the copyright, then you might want to include some language in the description of the NFT that grants a broader license than what's already granted under the general terms of the marketplace. The other thing to keep in mind is that not all marketplaces are going to police for whether the person posting the NFT and minting that NFT first and offering it for sale actually has the rights to do that. So you have some situations where people don't realize that they don't have the intellectual property rights to make something into an NFT. They might think, for example, if they purchased a painting, they might think that they have the copyright rights to reproduce that work by copying it, scanning it, making a digital image and selling it. But they don't actually have those rights in most circumstances unless that was specifically granted along with ownership of that physical work, which is extremely uncommon.
So let me jump right here. We have a number of other additional interesting questions, but I'm going to pause right now for our poll because we need to get our poll in before the before the program ends. So we're launching our poll. Hopefully you should be able to see that on your screen. Go ahead and answer the question to that poll and submit. We'll try to leave it up here for about a minute. Again, simply by answering the question, this is how you are kind of certifying your attendance at this CLE. And it's required for you to get CLE credit for attending this event. And we will turn momentarily, once this poll ends, to another question. And there are a couple questions from David Kalo, and they relate to the relationship between, say, the artwork itself and the NFT. And his questions in part are that, is the NFT really, it's a separate thing from the artwork? Is the NFT more just like a digital certificate that is affiliated with the artwork? Is it a separate thing, or is it somehow the digital image itself?
So you can, as the owner and seller of the NFT, you can specify exactly what you want it to cover. So essentially an NFT is just a tool that you can use to take advantage of these smart contracts. It's essentially a tool that you can use for any non-fungible asset to make it so that a purchase of that token will give you ownership over whatever it is that's described in that NFT. So oftentimes the most popular use right now is of NFTs is for selling a digital asset, but you can use NFTs for anything at all. So if you have something where you have a physical piece of artwork and you want to provide a certificate of authenticity and ownership of that physical piece of artwork, you could specify that your NFT is for the purchase of, a one-of-one limited edition physical artwork, and that this NFT would be a certificate of ownership. So you would have to also probably transfer physical ownership of that item and try to arrange for physical transfer. But this NFT could operate as sort of a quick and smart contract to show the actual physical purchase of physical items. Now, this could have a lot of use for things like land and other types of non-fungible assets in the physical world, just as much as it could for physical artwork or for digital artwork. So yes, you can use the NFT for any purpose that you want to use it for, as long as you describe it. Most of the platforms for sale of NFTs are designed for digital artwork, but you could design a platform or use another platform to have NFTs associated with physical works. The current platforms are not very well adapted for that, but you can certainly modify that or use the existing smart contracts for NFTs to do something like that.
So another question, this one comes from Carlos Garcia. What about choice of law issues? NFTs are sold on websites, people all over the place, servers in different countries. Is there, like, he's asking, is it presumed that the law applied is where the purchaser is located or something else? Do you know?
That's a really great question. So oftentimes these platforms will have a choice of law provision in their general terms associated with the platform. Oftentimes these platforms are based in the United States, and you're going to have some US contract law, perhaps Delaware law or something like that, that's going to apply as part of the contract terms. Now, without that kind of default, you would have to use choice of law analysis to figure out what law has the greatest connection to the transaction at issue. So as part of that, it would be a fact-intensive analysis that would look at questions like where the servers are located, where the purchaser is located, where the copyright holder is located, to try to figure out where that choice of law is most appropriate, and which sort of forum is going to have the most contacts with that particular transaction.
Excellent. Here is a question from one of our students, Bennett Kuhar, and I don't even know what he's talking about because I don't understand these terms. Does the first sale doctrine not apply to the digital image that would allow the purchaser to display that individual copy of the digital image absent a license?
Yeah, so the first, for those who are unaware, and hi Bennett, Bennett's one of my students. He was in my intellectual property class, so I'm glad that he's familiar with the first sale doctrine. So the first sale doctrine is this concept that when you sell an item that could have some kind of intellectual property protections, then you're giving the purchaser of that item the ability to resell in most circumstances. So with physical items, the first sale doctrine is pretty strong. When you purchase a painting, you're going to get rights to sell that painting, that particular copy of the painting, to somebody else. And the same is true for certain issues around patent law and other areas of intellectual property law. You know, you're not going to violate trademark law if you take your your Gucci bag that you purchased authentically and resell it to somebody else and it's still the same bag. There's a lot of different areas of intellectual property law where we try to say that for physical items, we're going to try to, as a policy matter, promote the alienability of physical items. We don't want the law to restrict people from being able to transfer physical items between them. Now, this gets a lot stickier when you're looking at digital assets. So oftentimes digital assets do not come with the same protections. So for example, if you have an ebook that you downloaded, oftentimes what you received is not a digital asset, but is actually a license from the ebook seller to have a copy of that item on your device. And oftentimes it's a limited license and it can be revoked. So they could take the ebook off of your device if they want to. So oftentimes with digital assets, things are controlled more by these licenses. And that's because every single copy of these works is going to oftentimes be considered an independent act of copyright infringement or an independent item, very much unlike a physical painting where you just have the one thing going back and forth. Whereas if you download a physical item, if you download a digital item, you're making a copy of that item. You put it on your backup hard drive, now you have two copies of the item. So it's much harder for the first sale doctrine to apply. Now, I think you can say that there might be, with these smart contracts and the language that's given as part of these contracts, that you have something that's similar to the first sale doctrine, but it's not because of the first sale doctrine, it's because of the actual transfer of those rights. So for example, with my Pink Sunrise, I'm going to share my screen again. So let's see, are you guys seeing Pink Sunrise right now? Yeah.
Yes.
So with my Pink Sunrise one, which includes the copyright right, I've said that this copyright license transfers, to the owner of the NFT for the duration of ownership of the NFT. So in this situation, that right to the license rights that are granted as part of ownership of this NFT are going to transfer from person to person who owns the NFT. But if you look at something like the Purple Sunset one that does not have the copyright right license included with it, you're only getting whatever it is that's granted as part of ownership of that NFT on that particular platform. So you'd have to look at the general rights that are associated with that platform to see whether there are certain rights that are extended on that platform. Is this a platform that includes limited display rights as part of the general sale? And then you would simply be getting those rights. So it's not like a first sale doctrine situation when you're looking at digital assets. There's very unique circumstances there, but that's a great question. So I see a question from Brian Glassman that I wanted to address while there's still time. He says, do you think that NFTs will wind up as the tulip bulb craze did in the 17th century? Now, this is really an interesting question, because I think that oftentimes people thought, let's say we saw in 2017, 2018, that there was this huge uptick in the value of cryptocurrencies and also the value of NFTs. So we saw the crypto kitties, for example, had a huge spike around that time. Now, many people thought of this as just a tulip bulb craze. This is something that was a bubble and it was going to burst. Maybe it's like any other craze, pogs, beanie babies, whatever it is. People try to benefit from the scarcity of items only so long as that scarcity is valuable, and only so long as those items are valuable. As soon as those items are no longer viewed as valuable in the public mind, their value decreases, their price decreases. So that could be true of NFTs. But I think that we've seen now that cryptocurrency has been pretty resilient and has started getting another spike, and we've seen a reemergence of NFTs as well. So my guess is actually that these are here to stay, but I think we actually need some legal reform to make it so that they are here to stay, and to make sure that they actually have value that can be maintained. I think it's likely that legal standardization is needed in order for these to stay, in order for NFTs to be sustainable and for their value to be sustainable. We can't keep operating in this lawless environment where the rights are not specified. And especially when these become more and more popular, we're going to get lawsuits over the scope of these rights. We're going to get people that are not just, right now, a lot of the NFT owners are sort of laissez-faire, cool cat sort of people that are not going to sue people for displaying the NFT that they purchased. But that might not be true for very long. And if we don't put some kind of legal boundaries in place to delineate those rights, then it might not be sustainable. We might have a crash. The value might never return. But I think if we want those assets to retain their value, we can have standardized contracts for NFTs. So this could be something like the NFT license 2.0, or could be another type of contract, but very much like we have things like Creative Commons tell us, some actual legal language that's enforceable, that people can consistently use from for every type of work that they want to use it for. We need to have something like that for NFTs too. We need to have a way for people to know what it is that they're purchasing. And we also need to change the public perception and make clear that you're not actually purchasing those copyrights, because some of the inflated value of some of these NFT assets, I think, is coming from misunderstanding of the public, belief that they're owning more than they actually own. And I think if we change that, we know that it can still be valuable to have ownership over something. We know that people want to hang the real Monet in their house. They want the real thing. The same is true for NFTs as well. But if we don't have contracts that actually put the expectations of the parties into some kind of language that can be enforceable in a court of law, this lawlessness is going to cause a plummeting in the price when people start to realize that they don't actually have the rights that they thought that they had.
Okay, excellent. I think that's kind of a big picture issue to end on. And so I think we'll call an end to the talk. First, let me quickly plug our next Faculty Spotlight CLE, which is on Wednesday, October 20th, 2021, from noon to 1 p.m. Professor Reggie O will be talking about implicit bias, dehumanization, and racial disparities in the criminal justice system. But for now, I want to thank all of you for joining us today for a really fascinating discussion. I want to thank Professor Laser for a really interesting presentation. And everyone have a wonderful evening and join us at our next event.
Thank you so much for joining, everyone. I really appreciate it.